welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. Vishal Tiwari versus Union of India and others, popularly known as the Adani Hindenburg case. The case revolves around accusations of stock price manipulation by the Adani Group, with the Hindenburg research raising concerns in a report published by it in January last year. The Adani Group faced accusations of malpractices to boost stock prices, prompting calls for a court-monitored investigation by an expert committee. The petitioner, Vishal Tiwari, had sought the constitution of an SIT to oversee the SEBI investigation and a direction to SEBI to revoke certain amendments. The Adani Group had denied all allegations, emphasizing compliance with regulatory norms. A three-judge bench led by the Chief Justice of India, D.Y. Chandrachud, and also including Justice J.B. Pardiwala and Justice Manoj Mishra, dismissed the plea seeking the transfer of investigation from the Securities and Exchange Board of India to a special investigation team. The court reserved its judgment on November 24th in the case and refuted all claims of conflict of interest against the member of the court-appointed committee. Notably, despite the expert committee finding no lapses by the markets regulator, the petitioner alleged conflict of interest by SEBI. The court, however, expressed confidence in SEBI's investigation, dismissing concerns about the expert committee's impartiality. The court stated that allegations against the members of the committee were unsubstantiated. Regarding SEBI's investigation, the court acknowledged that 22 of the 24 investigations into the allegations against the Adani Group had been completed. With regards to the pending investigations, the court directed SEBI to expedite the two pending cases, aiming for a conclusion within 3 months. The Chief Justice also highlighted the court's limited role in SEBI's regulatory domain, stating press reports are inputs, not proof of regulatory failure. Further, the bench rejected the petitioner's request to direct SEBI to revoke certain amendments made to the SEBI Foreign Portfolio Investment Regulation of 2014 and the SEBI Listing Obligations and Disclosure Requirements Regulations of 2015. The court found no valid ground to make such directive. State of Uttar Pradesh and others versus Association of Retired Supreme Court and High Court Judges at Allahabad and others. In a landmark ruling, the Supreme Court introduced a standard operating procedure concerning the personal appearance of government officials in court proceedings. The top court stressed that the power to summon government officials should not be wielded as a means to pressurize the government, particularly under the threat of contempt. The case in question originated from appeals filed by the state of Uttar Pradesh against the Association of Retired Supreme Court and High Court Judges of Allahabad. The appeals were filed in response to 2 orders issued by the Division Bench of Allahabad High Court, which raised crucial questions about the separation of powers, criminal contempt jurisdiction, and the frequent summoning of government officials. The orders from the High Court directed the Uttar Pradesh government to notify rules proposed by the Chief Justice of the High Court. The state government, citing a legal obstacle, sought a recall of the order. This led to the initiation of contempt proceedings against various officials. A 3-judge bench consisting of the Chief Justice of India, D.Y. Chandrachud, and Justice J.B. Pardiwala and Justice Manoj Mishra, collaboratively formulated the SOP. The procedure emphasizes the necessity for courts to exercise consistency and restraint, guiding them away from the arbitrary and frequent summoning of government officials. The SOP discourages summoning officials as the first resort and asserts that while the actions of public officials is subject to judicial review, frequently summoning them without a just cause is impermissible. The court emphasized that courts should allow as a first option the officer to appear before it through video conferencing, and if the personal appearance is directed, the reasons for it should be recorded. According to the SOP, the government officials shall not be required to stand throughout the hearing and should be required to do so only when responding to questions put forth by the court or making statements. Oral remarks to humiliate the official during proceedings should be avoided by the judges. The court must refrain from making comments on the physical appearance, educational and social background or standing of the official. Further, the SOP stated that the courts need to exercise caution when initiating contempt proceedings. The top court concluded that the High Court lacked the authority to direct the state government to notify rules proposed by the Chief Justice. Additionally, the power of criminal contempt could not be invoked against officials based on a recall application being deemed contemptuous. The Supreme Court has directed that the SOP must be followed by all courts across the country. Furthermore, it urged the high courts to consider framing rules to regulate the appearance of government officials in courts. S.V. Samudram versus State of Karnataka and another. In the instant case, the Supreme Court declared that a court operating under Section 34 of the Arbitration and Conciliation Act lacks jurisdiction to modify an arbitral award. The ruling came in response to an appeal challenging the Karnataka High Court's verdict under Section 37, subsection 1 of the A and C Act. The verdict came by a two-judge bench comprising Justice Abhay S. Oka and Justice Sanjay Karol, who made a reference to the 2021 judgment delivered in the National Highways Authority of India versus M. Hakim, asserting that it was outside the purview of a court to modify an arbitral award unless it conflicts with the specified grounds mentioned under Section 34. The case at hand involved Mr. S.V. Samudram, the appellant in the case, securing a construction contract from the Karnataka State Public Works Department. The construction work, however, was not completed in the stipulated period. For settlement and adjudication of dispute, the parties resorted to arbitral mechanism and an award was made by the arbitrator. The award was, however, modified by the senior civil judge by reducing the awarded amount. The decision of the civil judge was also approved by the High Court and the matter then reached before the Apex Court in appeal. The Supreme Court, taking into account the arguments of both sides, noted that the civil judge's decision did not align with the statutory provisions, emphasizing the limited nature of power under Section 34 and 37 of the Arbitration and Conciliation Act for interference with an arbitral award. The top court further highlighted that the civil judge had undertaken a reappreciation of the matter, modifying the order based on its own interpretation of the evidence, which contradicted with the legislative intent. Conclusively, the Supreme Court upheld the order passed by the arbitrator, affirming the entitlement of interest at the rate determined by him, and ruled in favor of Samudram, the claimant. The court then set aside the judgment of the civil judge and the High Court, which confirmed the said order. The top court then directed the state to promptly fulfill the payment obligations. With that, I am Ananya Singh. Thank you for watching. Your time and engagement are greatly appreciated. If you enjoyed the content, don't forget to like, share and subscribe to our YouTube channel and download the Verdictum app on iOS and Android for latest legal news.